evening, everybody. I'd like to express first my appreciation to WP UK for hosting me, and to all of you for coming out on a cold, wet evening to hear us. I'm going to talk this evening about sex and gender in the context of human rights law, specifically the European Convention on Human Rights, brought into domestic law by the Human Rights Act. And I'm planning to talk about absolute and qualified human rights, talk about how the GRA, that's the Gender Recognition Act, arose in light of a case called Goodwin, and how and whether changing the goalposts could change the balance, and what's meant by a proportionate means of achieving a legitimate aim, and then finish with what other human rights are in play. So I hope you aren't too overwhelmed with that idea. I shall keep it as non-legal as I can in the context of what is going to be quite a legal talk. So let's start with human rights law. The purpose and implementation of human rights law is too frequently misunderstood as existing in, and forgive me, a binary, whereby something either is or is not a human right, and once established is brittle and unbending. Another misconception about the Human Rights Act is that it is enforceable between individuals. It is not. It's fundamental to the rule of law that everything which is not directly permitted to the state is forbidden, while everything that is not expressly forbidden to the individual is permitted. If you get that the wrong way round, you end up with a totalitarian state. So human rights in this context means the obligations on the state. Your rights under Article 2 is your right to life, means the state must not murder you. The Human Rights Act obviously doesn't stop another individual from murdering you, although it does require that the state protect citizens from murder insofar as it is able to do so. There are only 3 articles of the Human Rights Act which are absolute. Those are your right to life, your freedom from torture and inhuman and degrading treatment, and your right to a fair trial. Those are the only 3 absolute rights. As well as those, you have qualified rights. That is, rights which can be interfered with in some circumstances. Freedom from slavery and forced labour, for example, guaranteed by Article 4 of the Human Rights Act, doesn't mean that a community punishment order is a breach of human rights. The others are your right to liberty, your freedom from retrospective punishment, your right to private and family life, freedom of belief, freedom of expression, freedom of assembly, right to marry, and your right to enjoy all of these rights without discrimination. I'll focus for a moment on Article 8, which is your right to private and family life, because this is the most malleable and the most wide-ranging of all of those articles, and because it was an Article 8 case from which the Gender Recognition Act and the current discussions over sex and gender arose. Article 8 in full states that Article 8.1, everyone has the right to respect for his private and family life, his home and his correspondence. Forgive the male pronoun there, it's how it's all done. There shall be no interference, this is Article 8.2, there shall be no interference by a public authority with the exercise of this right, except such as is in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. So quite wide-ranging. So this covers not just the obvious, such as one's right to live with family members and to privacy of correspondence. It also applies to what has variously been described as physical and psychological integrity, physical and social identity, and personal autonomy. I would probably sum that up as a person's sense of self, and that is a protected right. But what Article 8.1 gives with one hand, Article 8.2 takes away with the other, because the state may interfere with someone's rights if it is necessary in a democratic society to do so. And this is often described in terms that some of you may be familiar with, a proportionate means of achieving a legitimate aim. So how does all of this apply to sex and gender? Well, that would be from the 2004 case in which Christine Goodwin took the UK government to the European Court of Human Rights, arguing that the government's failure to recognise her in law as a woman, and she was a transsexual woman, breached Article 8 of the Human Rights Act, the European Convention on Human Rights. She had suffered discrimination that included being unable to marry her male partner, difficulties caused by an unequal pension age, and detriment caused by her birth certificate showing her as male, which outed her as trans whenever she was compelled to show it. So she was unable to go about her daily life unimpeded by that mismatch between her legal sex and her outward presentation. She said there was an unjustifiable breach of Article 8. The government maintained that although there was interference with her private life, nevertheless that interference was proportionate. The court found in her favour, pointing out that there was no threat of, I quote, overturning the entire system, given that the number of transsexuals in the UK was estimated below 5,000, and that although there would be legal repercussions, they said these were not insuperable if confined to the case of fully achieved and post-operative transsexuals. Now, obviously, that is terminology which is very much no longer in use, but that was their proportionality assessment at that time. Now, this is exactly the type of balancing exercise that is done in every human rights case where a qualified right is in issue. So let's look at that. What is meant by proportionate means of achieving a legitimate aim? And would a shift in the goalposts affect that balancing exercise? Where an individual maintains that there is a potential interference with their personal autonomy, it is for the state to justify any interference. The same terminology is used in the Equality Act to require a service provider to justify any discrimination against a service user. The aim must be legitimate and the means used must be proportionate. What exactly this means will always be an equation, and the mathematicians here will know that if you alter one side of an equation, however slightly, you will alter the outcome. In my own field of immigration law, we have dozens, if not hundreds, of cases which inform the balance between, on the one hand, the right of the migrant to establish a private and family life, and on the other, the right of the state to interfere by requiring her mostly to leave the country. There are multiple factors which weigh in the balance on each side, and the existing statute and case law tells us what those factors are likely to be. There have been a small but significant number of cases also weighing the balance between religious rights and gay rights. We can derive from those cases that generally it is proportionate to expect a service provider to accommodate the needs of the service user. The case of Lillian Liddell, the registrar who did not want to perform gay weddings, for example, or the Bulls who attempted to refuse service to a homosexual couple in circumstances where they say that they would have refused service equally to a heterosexual couple. The exception has been the recent Asher's Cake case, where the bakery had refused to ice a gay rights message onto the cake. And that was because the court accepted that the bakery hadn't refused service to the customers because they were gay, but rather because they would refuse that particular service to any customer at all. There are no cases, to my knowledge, which address the tension between sex and gender, which arises in the context of moves to replace gender reassignment as a protected characteristic with gender identity. Why is this even an issue? Are they not the same thing? Well, this is an imperfect analogy because nationality does not exist outside society in a way that reproductive sex does. But a near analogy would be replacing nationality in law with national identity and then allowing self-identification for a passport. There would be very clear benefits, but also quite clear pitfalls. At the moment, women and men are defined in domestic law through Section 212, subsection 1 of the Equality Act, which says a woman is a female of any age and a man a male of any age. Those refer to sex classes. Section 9.1 of the Gender Recognition Act then also provides that a person with a gender recognition certificate becomes a male or a female, their acquired sex, for all purposes. The law is now quite clear that transsexual people, that is, those who are undergoing or have undergone gender reassignment, are protected by Article 8. So David Elving QC, in a case called AB, described that as now unassailable. In Rees in the UK, an older case at the European Court of Human Rights, the court commented that this group form a fairly well-defined and identifiable group. And that becomes relevant when you are looking at a proportionality assessment. What is proposed, though, is to replace gender reassignment with gender identity. And gender identity goes well beyond what in law is understood by gender reassignment. Gender reassignment assumes some level of medical diagnosis and treatment, as envisaged in the case of Goodwin. And that is something which can be assessed externally to some degree. However, gender identity is a matter exclusively of self-perception. It's featured in law in the recent case last summer of Elam Kane, where the court said sex is now more properly understood to refer to an individual's physical characteristics, including chromosomal, gonadal and genital features, whereas gender is used to refer to the individual's self-perception. So how do we legislate for self-perception? The goalposts here have moved from a fairly well-defined and identifiable group to a much more unidentifiable group. It's now, I think, clear that a person's sex and their projection of a gender identity are two quite separate things. I will get to the implications of this for the proposed reform shortly, but first let's look at that underpinning of self-perception, because that is what is proposed by Stonewall et al., and it relies on that gender identity being innate. The idea of an innate characteristic leading to protected human rights is by no means new. So, for example, in refugee law, a person may need international protection if they are at risk due to race, religion, political opinion, nationality, or membership of a particular social group. And a particular social group is one which, among other things, has an innate or immutable characteristic. So that leads us to this question. Is gender identity innate? And this, I think, is the crux of the tension with feminist analysis, because applying the Stonewall glossary, gender is, and I quote, largely culturally determined and is assumed from the sex assigned at birth. While gender identity is, and again I quote, a person's innate sense of their own gender, whether male, female, or something else. How can you have an innate sense of what is culturally determined? And what does that mean for women? Because if we agree that humans have an innate sense of gender, then we are agreeing that women participate not by structural compulsion, but by innate affinity in a system which historically, globally, and persistently regards us as inferior to men. And I would argue very strongly against the crystallisation of that view into law.
Yeah.
Having said that, many people clearly do believe that they have an innate gender identity, fixed and immutable, and that a person is a man or a woman depending on that person's self-perception rather than on their biological sex. Many others, myself included, believe equally firmly that they do not have such an innate gender identity, pointing to the temporal and cultural variations in gender, indicating that social projections of gender are neither innate nor immutable. It is worth considering whether the better way to accommodate within a human rights framework the issues in play is within the context of Article 9, freedom of belief, rather than exclusively within Article 8. I mooted this on Twitter and got a rather sharp intake of breath from the entire internet. If you describe something as a belief, many people hear that as claptrap woo-woo, which is really not what I was saying. Freedom of belief extends beyond the right to religious practice and incorporates the right to hold and to express deeply held beliefs. The European Court has described it as one of the most vital elements for those it affects. And they've said the pluralism indissociable from a democratic society, which has been dearly won over the centuries, depends on it. That pluralism has, I think, been rather lacking in this discussion, as I think some of the protesters at the wrong venue shivering outside can attest. So, could a belief in innate gender identity fall within the protected characteristics of belief? The test for that is set out in a case called Granger and Nicholson. The belief must be genuinely held. It must be a belief and not an opinion or a viewpoint. It must be a belief as to a weighty and substantial aspect of human life and behaviour. It must attain a certain level of cogency, cohesion and importance. And it must be worthy of respect in a democratic society, not incompatible with human dignity and not conflict with the fundamental rights of others. There is, of course, an argument to be made that there is at least some conflict with women's rights. But the better argument, in my view, is that if belief in innate gender is protected, so too is disbelief. Because both Article 9 and the Equality Act protect disbelief as well as belief. Failure to share someone's belief is not the same thing as mockery or disdain for it. We also have, which I don't have time really to explore, freedom of expression, including our right not to be compelled to hold a viewpoint with which we disagree, the right against compelled speech, and freedom of assembly. It cannot be beyond the wit of the legislature to protect the beliefs of those who believe they have an innate gender, protect the rights of others to agnosticism or downright atheism on that point, while also maintaining sex-based protections. And that brings us from the theoretical to the practical. At the moment, there are exemptions in the Equality Act to protect single-sex services, whereby a service provider may opt for a single-sex service in certain circumstances, and those are where women have experienced trauma, for example, women's refuges, rape crisis centres, domestic violence services, where women need safety, privacy and dignity, such as in women's prisons, where women are physically at a disadvantage, such as women's sports, and where a single-sex provision exists to repair the historic sidelining of women and marginalisation of girls resulting in unfairness, such as in all women's shortlists. Those exemptions can be used to exclude from female-only services male people with a protected characteristic of gender reassignment, as long as this is a proportionate means of achieving a legitimate aim. So it is lawful to provide a service to persons of only one sex, but does that include, or not, those who have acquired their sex through a gender recognition certificate? It is lawful to discriminate on the basis of gender reassignment if it is a proportionate means of achieving a legitimate aim. But does that mean discrimination against males who hold the protected characteristic of gender reassignment, that is, trans women who do not have a GRC, or against females who do, that is, trans men who do not have a GRC and/or trans women who do have one, or both? A perplexed service provider might turn to the EHRC for guidance. Their website stated categorically, until 6 weeks ago, that it was unlawful to exclude trans women with a GRC from single-sex services. It now says that a business may have a policy about providing its service to transsexual users, but this policy must still be applied on a case-by-case basis, and that a birth certificate proves legal sex. This is entirely ambiguous, because it's silent as to the effect of a GRC. Others in the field are now arguing that it is now, and always has been, entirely lawful to provide services to biological women only, but that sits rather uncomfortably with the EHRC's recent guidance, and I think with the Scottish guidance, which continues to say it would be unlawful. So if the statute can be argued either way, guidance tends towards female-only space being open to biological and legal females. What about case law? Now, case law on this is very limited, but some support is found in the comments of His Honour Judge Jeremy Richardson QC in a case called Green. Now, in that case, the court was dealing with an application by a male prisoner who wished to be considered female and to have access to tights, wigs, a prosthetic vagina and sanitary towels. Green did not have a dysphoria diagnosis and therefore would not meet the current criteria for a GRC, but was treated by the prison and the court with the courtesy of being referred to as a woman, despite being neither biologically nor legally female. And what the judge said was that, "I find it impossible to see how a female prisoner can be regarded as the appropriate comparator. The claimant is a man seeking to become a woman, but he is still of the male gender and a male prisoner. He is in a male prison, and until there is a gender recognition certificate, he remains male. A woman prisoner cannot conceivably be the comparator, as the woman prisoner has, either by birth or by election, achieved what the claimant wishes. Male to female transsexuals are not automatically entitled to the same treatment as women until they become women." I know that an academic lawyer has criticised my reliance on that case of Green, suggesting rather startlingly that the judge was motivated by prejudice. However, this is not the only case in which the significance of the GRC has been highlighted. There's also a 2017 case called HY&LW involving pension ages, where the upper tribunal held the first-tier tribunal erred in law in holding that the claimant was entitled to be treated as a woman in respect of a period before the gender recognition certificate was issued. So in that case, the GRC was also treated as a bright line. The significance of the GRC, then, is to bring the individual within the legal sex class of their acquired sex. This may or may not include, for the purposes of Equality Act, single-sex exemptions, and that will have to be resolved conclusively before any changes to the law are made. At the moment, if a gender recognition certificate does bring people into the Equality Act single-sex exemptions, then amending the GRA to encompass a far wider group of people will obviously bring a far wider group of people within that legal sex class. If not, it is still up to the frontline service providers to work out, with the litigation sword of Damocles poised above their head, what to do next and who they can and can't offer services to. The balance between public and private interests was formulated quite carefully in Goodwin. And it is also worth noting that it's very unclear from any of the guidance on exemptions and from any of the available cases that women's Article 8 rights to psychological integrity are considered. We don't have any consideration here of the effect and the psychological integrity effect on women who have experienced male violence if female-only services are no longer available to them. Or what about women from some faith groups? We talk a lot about exclusion here and are seeking not to be exclusionary in law, but we're also, in changing these things, excluding other women. Not all women will want or need female-only provision, but for those who do, their Article 8 rights too are worthy of consideration. The balance of private and public interests was formulated quite carefully in Goodwin and heavily focused on the context of dysphoria. It's fundamental that law should be coherent, usable, and workable. What we have is already very finely balanced, and that is, I say, at risk if that balance is displaced by a nebulous concept of internal gender identity to which societal buy-in is minimal, scientific consensus uncertain, legal opinion divided, and the affected communities at loggerheads.